Are FMLA medical documentation requirements confusing? Imagine needing time off for a serious health issue and feeling overwhelmed by paperwork. That's often how employees and employers feel about Family and Medical Leave Act documentation. The FMLA allows eligible workers to take up to 12 weeks of unpaid, job-protected leave for health or family reasons. But to qualify, employees must provide medical certification from a healthcare provider. Understanding what counts as a serious health condition is the first challenge. The law says it involves illnesses or injuries that requiring inpatient care or ongoing treatment. But what exactly qualifies? It can be tricky because some conditions are obvious, like surgery or hospitalization, but others, like mental health issues or chronic illnesses, may not be. Employers need clear proof that the condition is serious enough to justify leave. The medical certification form is another sticking point. The Department of Labor provides a standard from asking for details about the health condition, treatment plan, and how it affects the employee's ability to work. Healthcare providers fill out this form, but it can seem complicated. It asks for specific information, like the expected duration of the condition and whether the employee needs leave intermittently. Sometimes, providers find the questions confusing or intrusive, leading to incomplete or vague answers. Timing is also a concern. Employees are generally asked to submit certification within 15 calendar days after the employer requests it. But getting a healthcare provider to respond quickly can be tough, especially if they are busy or if the employee's condition is urgent. Missing the deadline might mean the employer denies the leave request. Privacy is another sensitive issue. Medical information is protected by laws like the Health Insurance Portability and Accountability Act. Employers can request only the necessary details to verify the need for leave, but they must handle this information carefully. Employees often worry about what information is too personal to share, which can add to the confusion. Sometimes, employers need clarification or a second opinion if the certification seems incomplete or unclear. This process can cause delays and make employees feel mistrusted. Healthcare providers may not be familiar with FMLA specifics, so their responses can vary in detail. This inconsistency can make it hard for employers to decide if the employee qualifies for leave. To make things easier, employers should give clear instructions about what documentation is needed and when. Training HR staff on FMLA rules helps ensure consistent handling of medical certifications. Employees should communicate with their healthcare providers early and follow up to make sure the paperwork is complete and submitted on time. Both sides should understand the privacy protections around medical information and know what can and cannot be requested. In the end, the medical documentation process under the Family and Medical Leave Act can seem confusing because of broad definitions, detailed forms, tight deadlines, privacy concerns, and variable responses from healthcare providers. But with clear communication and understanding of the rules, both employees and employers can navigate this process smoothly and avoid unnecessary disputes or delays.